That's fine. I just flail around. You know, Christine's pretty brave to sit next
I would like to call this board meeting to order, please. First of all, I would like to give you an overview of the structure of the meeting tonight. The board will hold a public hearing to take public comment on our intent to modify one rule and repeal two others. During public comment, the meeting will only pertain to the rules. So right now, that's all that will happen. We'll talk about the rules. Then we will reconvene our board meeting to hear the updates to the proposed HR policies and procedures. The board will then discuss the policies and procedures, but will not take any formal action on them or the rules this evening. So I want everyone to know that we are not taking any formal action tonight. There will be an opportunity for public comment on the updated proposed HR policies and procedures during our regular meeting, which we will convene to after this portion of the meeting. There will also be an opportunity for public comment on anything not on the agenda. I would like to recess this board meeting to conduct the public hearing. Deb, I would like to charge you with discussing the rules, please.
Good evening. Tonight we are discussing three separate rules. Your current rules cover contested case procedures, reduction in force, and employee discipline. So the two rules that are out for proposed to be repealed are your employee discipline and your reduction in force. And those items, the proposals that they would be taken out of the rules section and put into policy and procedure. With regard to your contested case, that rule is out for amendment. And I want to make everyone aware at the outset, as you're probably aware, we've had three separate forums where we've met with Faculty Senate and Staff Senate and the EA. And so as a result of that, we've already made significant changes to the rules. And so the rule that was placed on the website originally of our proposed change has already been modified. And so a few of those key changes that I want to make you aware of tonight. One is the original proposed rule said that the board would not hear the matter in any context, that the hearing officer would decide it and that the hearing officer's decision would be final. After some of the forums, we have modified the rule, and what will happen is the hearing officer will still hear the matter. That hearing officer will make proposed findings of fact and conclusions of law. Then both parties can submit written exceptions to that, meaning their objections to that proposal. And then ultimately, the board will receive the full record of that proceeding. So they'll have a transcript of the proceeding or an audio of it and can review that in its entirety. And then the board can either accept those findings, modify them, or reject them. So one change that has already occurred to the rule is that the board will have a role in contested cases. They will not be present at the actual hearing, but they will review the entire record. The purpose of our hearing tonight is so that the board can hear your feedback. As I said, we've already had three forums, which have been very helpful. We've already made changes. We've gotten some constructive feedback. So the job of the board tonight is to listen to more feedback so that we can think about it, digest it, and then make changes as necessary. Thank you.
Thank you, Deb. This is the open public comment period. When you come to the podium, I would like you to state your name and tell us your comments and your feedback, please. Feel free to come at any time, please.
My name is Rich Laidlaw. I teach chemistry and math here.
Just one moment, please. This is not working.
Oh, thanks.
Gotta be real close, Rich.
Real close.
Yes, perfect. Thank you, Rich.
Members of the Board of Trustees, I'm only going to talk about Chapter 1, Rules of Practice and Procedures for a Contested Case. According to an email sent out by President Schaefer on Monday of this week, the proposed amendment to Chapter 1 of the Rules of Practice has been updated on Friday of last week. There's now a new version of the proposed amendment to Chapter 1. The first version of the proposed amendment from 45 days ago states that the hearing officer's written order shall be the final agency order. The new version, which by the way has not been made available to us or the public, apparently requires the Board of Trustees to make the final decision on a contested case. This is a substantial change from what is being proposed. And so I guess I'm a little confused. And my question to the board is, which of these two versions of the proposed amendment are we supposed to comment on tonight? The first proposal from 45 days ago, or the new proposal from Friday of last week, which has not been made available to us?
I will ask Deb to answer that question.
I think it would be fair for you to comment on either, simply because neither has been, I guess, approved, if you will, by the board. But what I can tell you is the new version, the updated version, is really what we will be having the board ideally contemplate and then vote on. So I would say, for the most part, your comments should focus on the updated version, because that's really the direction that the rule is headed. But any comment is certainly open for you to share.
Thank you. Next.
I'm Kathy Rogers. I teach here at the college I teach computer science courses. My concern about the rules is you as a board voted for these 3 years ago. We instituted them only 3 years ago. We had a very qualified legal team providing advice on this. What has changed? That within 3 years, we're tearing this apart, changing how we RIF employees, changing the discipline procedure. I guess I want to know why. Are we going to have to change our rules, policies, procedures every 3 years? This would be a never-ending process. And at this point, that's the only comment I have to make. I don't know if you have an answer or not.
Thank you. Thank you. We'll take that under consideration. Thank you very much. Next. Deb.
Thank you, Madam Chair and Board of Trustees. I'm going to speak up here kind of as a community member today. I guess I'm a heavily invested community member because I also teach here. But one of the things that I really enjoy about LCCC and love about LCCC is the community and the fact that this is the community's college. And that was very evident here a couple of months ago when they passed that bond issue. I think that they spoke loudly that they support us. And I think that's great that we're the community's college. Kathy pointed out 3 years ago that these rules were proposed, and I guess we're the anomaly in that we have these kinds of things in rules. But 3 years ago, the board was faced with the situation that there was an administrator here who had, you could say, abused employees, and I don't know what your thinking was 3 years ago, but what I interpreted from these rules 3 years ago was that you said, well, no matter what the governance model looks like, and your governance model says that procedures belong to the president, no matter what the governance model looks like, that there's some rules that we're going to act under, that we're not going to allow administration to deny people a contested case, that we're not going to allow them to misuse employee discipline procedures, and that we're not going to allow them to use a reduction in force as a way of getting rid of people. Now, I have no reason to believe that our current administration has any ill intent with changing these rules to procedures, but as a community member, I don't think we're the anomaly. I think we're innovative. That we're saying that this is the community's college, and employs community people, and these are some things that we aren't going to allow to happen. And so we're going to make these rules, and we might be the only ones, but we're innovative and not the anomaly. So that's all I have to say.
Thank you, Deb.
Hi,
Hello.
my name is Arun Goel. I'm representing as a community member from this town. And I used to have a different role, but right now I am on leave of absence. So I'm enjoying my good time. I'm really concerned. I came to this town a few months ago. I about these rules, what I've heard about it 3 years ago, what I'm hearing from my colleagues here and my community members, that these rules are being changed. And I've talked to a lot of students over the last 6 months or 8 months, even last 2 days. The students are really concerned because they have been telling me that we are very busy in changing all the rules, regulation, HR and whatever, but we have not done anything for students. They have not seen anything tangible that what we have done as a community for them. They have not seen anything in their hand that made difference in their life. So I think my request to board will be to kindly let us as a whole, from the community side, let's work for that. Before we spend all of our time and energy in HR policy, rules and regulation, changing, threatening, all those things, let us do something for our students who can see this is what I have got after 3 years. Thank you.
Thank you very much. Anyone else?
How can I speak? My voice is loud, so I'm not shouting, so please, I want everybody to know I'm a very sweet talker. This is my sweetest talk.
Thank you.
Madam Chairwoman, members of the board. My name is Greg Hacker. I'm an attorney in the community. I'm here speaking on behalf of the organizations of the Wyoming Education Association, the LCCC Education Association. And I would also add that I'm a community member and a taxpayer in this community as well. And so there's a certain element of that perspective that I have, because as with any governmental entity that is part of my community, I don't like to see unnecessary time, effort, and money being spent, particularly when the results are going to be problematic or create additional issues down the road. Briefly, I want to remind the board initially when it's addressing the repeal of these rules, that the core of these rules, whether they have been in rule or policy, have been in place at the college for at least 25 years, and if not longer. I was attempting to find out the exact history of the rules prior to that, and I can't verify exactly what I've got, so I'll speak from 1989 to the present. 3 years ago, following a significant amount of employment activity under your former president and a number of appearances before the board, some of you were on that board at the time, some of you were not, so some of you will recognize me certainly, if the others of you don't. There was an effort underway by the board, the college's legal counsel, to revise those rules. The rules were thoroughly reviewed, public comment was taken, a number of drafts and versions of the rules were made, and the issues that, what I would call the defects in those rules, were addressed and revised at that point. Since that time, I am unaware of, and I would have never heard an explanation as to why the rules need to be changed, particularly in the manner that they are being changed or proposed to be changed. I understand the representation that there is a movement of certain policy items out of, quote, rule and into policy and procedure. To a certain degree, I can understand it. That makes some sense. There are some things that the board adopted under the terminology of rules that are probably a little bit unusual. Not many governmental agencies have all of their personnel policies in, quote, rule. That being said, there isn't anything inherently wrong with having them be in rules. They're just as abiding and effective and useful and functional in rule as they would be in policy. That by itself is not a good reason to repeal them and make the changes. The second point I would add to that is this is not just an exercise in moving policy items, but this is perhaps in my, I don't know how many years now, nearly 15 years of practice, the large, and working with a variety of governmental entities, cities, counties, state agencies, school districts, community colleges, University of Wyoming. This is the largest wholesale revision of personnel policy simultaneously that I have ever seen. And it has led to a substantial amount, I think, of confusion, anxiety, and complication at the college level with faculty, with staff. And I think in part that is a direct result of a lot of changes being made that don't need to be made and all being made at once. The conversion of these rules into policy also reflects the fact that this is providing an opportunity for substantial rollbacks and employee rights to take place. And I don't want to address those in detail because largely those are addressing the procedures and policies that are being proposed which replace these rules, and this is probably based on Madam Chairwoman's explanation at the outset of this meeting, probably not the best time to address those in detail. I have provided to the board written comments on behalf of the clients that I represent, which address to some degree those issues. But this is more than just moving items around in rules. This is a wholesale rewrite of policies that have been in place and working largely very well for 25 years. I have a concern about the fact that I'm here to make comments on a rule that I've never seen. I have a question, if I will address it to Madam Chairman, if she may refer to legal counsel or not. When is the rule going to be published? Is the board going to then proceed to have public comments in the hearing on the actual version of the rule that they're proposing to address, or is this intending to be the board's one and only public proceeding on that point?
I will refer this to our attorney.
We will certainly make sure that the new version gets on the website even as of tomorrow would be certainly doable. As to whether or not we will hold another public comment, we will have to get back to you on that.
It would be my position that depending on what's in the rule, and I've already heard some significant changes, I don't know if there are other changes that have not been identified tonight or not. I think it's entirely likely that in order to comply with the Administrative Procedures Act, the board is going to have to republish that rule, renotice the public hearing, and renotice public comments in order for any action on the repeal of that rule, or that, particularly the adoption of the new rule. I guess it would be Chapter 1, the amendment to that rule, in order for that to be a valid legal exercise. And I don't think the board wants to waste its time changing rules if they're not going to be valid and enforceable. I would address specifically the changes to Chapter 1, the rules of procedure for contested cases. The rules that exist now, again, have been the product of 25 years of use and a thorough revision 3 years ago. They have been greatly improved to the point to where they are among the better administrative procedure rules for contested case hearings that I have seen in my practice, which is largely administrative hearings before governmental entities. They're not perfect. You know, if I were writing them, I would tweak things here and there, but they are largely reasonable, fair, and represent both the college's interest and the employee interest in the process. The substitute proposed rule does none of those things. What the version that I have seen essentially provides no guidelines, no instructions, no timelines, no procedural steps that would be followed, starting with the initiation of a request for a hearing and following through to the conclusion of the hearing, and thus leaves the implementation of every hearing to be ad hoc. Every hearing officer who is hired who runs the hearing will then have to run it differently. There is a requirement that the rules are compliant with the Administrative Procedures Act. That's all well and good, except the Administrative Procedures Act is largely guidelines. It isn't actual steps of procedure. And the Administrative Procedures Act does not address all requirements that are present under constitutional due process requirements. So you can have a APA required compliant hearing, but not a due process compliant hearing. And so, because the hearing that is conducted in the board's name by the hearing officer the board hires is essentially the board's hearing, and liability for the board for breaches of due process or other legal violations fall to the board, not the hearing officer who made them. It is definitely in the board's interest to have developed and thorough rules of procedure for contested case hearings. To leave it open and have every hearing officer who might be hired run it a different way, skip steps, shorten timelines, not only allows for the likely possibility that there will not be due process guaranteed, but it also means that different employees are going to get different amounts of due process, different amounts of fairness, and different amounts of opportunity. And I don't think that's what this board wants. I would also add a concern regarding the rules and due to the lack of specific explanation as to how the hearing officer will be selected. In the last round, 3 years ago, I provided public comment to the board and the board's legal counsel and recommended a procedure which was then present more or less in the state statutes for tenured teacher terminations. That is, that the hearing officer was jointly selected between the two sides. That affords the two sides to agree on one. It eliminates the greatly eliminates the possibility that you end up with a hearing officer that the one side objects to. The board did not adopt that in totality, but it adopted what I would consider a reasonably improved procedure over what was there, which is, under the current rules, when there's a request for a hearing, the board and the employee, and these are not just, by the way, limited to employees, all your contested cases, whether they're involved employees or not, have to be under this process. So you could have student issues under these rules, you could have contractors under these rules, you could have a variety of people under these rules. But the board and the person who's asking for the hearing take 5 days to try to negotiate a joint selection of the hearing officer. If the hearing officer can't be selected, then the board goes ahead and hires the hearing officer. It at least affords some opportunity for a mutual agreement as to the hearing officer. Under the new rules, that is eliminated. And all it says is that the college, not the board, but the college will hire the hearing officer. That is ambiguous language that is problematic, because when you get to a contested case hearing, there really isn't such a thing as the college. At that point, you have a bifurcation. You have the board, who sits in a judicial capacity, as though it were a judge, and you have what I would, for lack of a better term, call the administration. It's the side that essentially is advocating, in the case of an employment issue, advocating for termination. The president, for example, or the administration, who's ever in that role, functions like a prosecutor. They're going to put on the case at the hearing, and the board is going to, or their hearing officer is going to listen to it. The language that currently exists is problematic because by saying college, it implies that the president or the administration is going to select the hearing officer. That would be the equivalent. How would you like it if you were at a criminal trial, you were there for your defense, and the prosecutor, not the defense, got to select the jury? You had to sit there while the prosecutor got up and said, these are the people I want on my jury. We don't do jury selection that way. Both sides jointly selected. There's a reason for that. You get a balance and a fairness. So under the rules, you have an ambiguity, which is going to come up the very first time you have a hearing under this rule, which is who's going to pick the hearing officer? Is it going to be the president? Is it going to be the administration? Is it going to be the board? Who is the, quote, college in that circumstance? I still think it's a bad idea to not allow the aggrieved employee or other person asking for the hearing some effort to be able to jointly agree on a hearing officer. If you do that and they can agree on it, you eliminate the possibility that that person is going to make a collateral attack on the hearing and say, a biased hearing officer was selected, I never had a chance to review it. It's greatly in the board's interest to have that kind of procedure, and it makes absolutely no sense to have that removed. I am glad to hear that the board is not acting on the rules changes or on the procedures tonight. One of the problems you have is the way this is being approached, that all really needs to be done simultaneously, because when you remove the two rules, chapters 2 and 3 of the rules, you essentially shatter the mirror, if you will, of the employment structure at this college. Unless you have procedures and policies directly in place to take care of that, you're going to affect chaos, quite frankly. And that may last for some time until the whole situation worked out. The final thing that I would say is that, excuse me, I got cold now. Got choked up. Not emotionally, just. No, I've got some. And I don't need to take any more of your time, but I have a concern that the repeal of the rule and moving of these definite policy statements on the legal status of employee rights, whether you're a continuing contractor or not, what that means, whether you're an at-will employee or not, and what that means. That those are being placed not in policy, but in procedure. Those are not steps of implementation of a board direction. Those are board-level policies. That's one reason they're in rule, not in something subordinate. Under the college's procedure and policy for creating procedures and policy, procedures are not actually supposed to be or adopted by the board. Under that rule, procedures are approved by the president after going through steps. If the board adheres to that process that's in your own policies and procedures about creating policies and procedures, those decisions are ultimately going to be made by the president in creating procedure and not by the board. At a minimum, which I think will also create questions about the legal enforceability of those standards when they have not been formally adopted and voted on by the board. Whether, if you want to call them procedures, that's fine, but they need to be and should be voted on by the board for approval and not left for the final approval of the code. Thank you.
Thank you very much. Is there anyone else who would like to speak? Is there anyone else who would like to speak? If not, I will adjourn this portion of the public hearing, and we will take a 5-minute break approximately and reconvene after that. It's 7:25, about 7:30. How's that? We can all get something to drink and whatever.